welcome to the Priggya Arora Show, where we discuss aspects of law and entrepreneurship with people who have been there and done that. My name is Priggya Arora, founder of PA Legal, an intellectual property law firm, and our guest for today is an inventor and invention coach and founder of Inventor Smart. Welcome, Brian Freed, on the show.
Thank you for having me, Priggya.
Perfect. So, Brian, how are you doing? How is everything at your end?
Everything's great. And it's amazing that we can be together and connected here from India all the way to New York.
Yeah, perfect. So, Brian, just let's start with something fun as a warm-up. What is one thing in life you cannot live without?
I would say right now, it's my cell phone. I think a lot of people might say something different, but the fact is, I think we all need our cell phones right now. It's the total portable way to be connected, whether it's your personal life, your business life, your entertainment, whatever it is, right? It's all on our phone. And that's why I got the biggest, best phone that you can, which is the Samsung S22. So I still have my little stylus in here to take my notes, so I can't live without it.
I know, and I love the way how technology has developed from phone booths to cell phones.
Absolutely. I had the opportunity to interview the gentleman who invented the cell phone, Marty Cooper. Wow. And he's got an unbelievable story, an inspirational story, and you should definitely check it out, and your listeners at some point. It's on Inventor Smart. Actually, it's on Got Invention show, which you can listen to his interview. He was very inspirational on there.
Awesome. We'll tag this interview in our description so that it is accessible to people.
Great.
Yeah. So, Brian, can you tell us something about your life story and how you reached to where you are today?
Well, I'm an inventor, and I realized back in the day, I reflect on it now to realize, like, when I was growing up, I was very intuitive and thinking about how things worked and looking at other people and what they were doing. And I always knew that I was an inventor, but I just didn't know really what it meant or what to do with it until I got a little bit older. And I said, I have some pretty good ideas. I think that I might be able to do something with them. So I started to take them a little bit more seriously and start to jot them down. And in my life, I got involved with different marketing initiatives. And when I was coming up with things, I was looking at things from from a consumer perspective. I can appreciate that this is something that I need for myself, but the others need it. And how big of a opportunity is there to actually make some money with it? So I started to really gauge what kind of products I had, to who would use it. And I started to work on them. And then I started to have some levels of success with some of my inventions, where I was on QVC for many years, and I had my products in retail stores, and I just kept doing it. And I realized that I was nothing special. If I could do it, so can other people. And they started to ask me for help. So from there, I sprouted into running inventors groups. So I've been running inventors groups for over 15 years. I've gotten 12, I think I'm 12 or 13 patents, issued patents, and I have a couple more pending. So for the IP side of this conversation, that definitely comes in handy to know where that part is. I've had over 100 trademarks that I built a brand out of in different classes of goods. I understand the trademark law. And between the inventors clubs, and I've authored a couple books. My latest book just came out last week. It's called How to Make Money with Your Invention Idea. And it's on Amazon and Kindle and all that ebook. And I also have been just continuing to manufacture my own products, license my own products. So I bring it to a company and that has distribution and manufacturing capability. I add my idea, my product onto their product line, and I earn royalties from it. And I've been doing the same thing for other inventors for over 15 years. So I help them to license their products, to earn royalties that I share with them. And I help to manufacture products. So if they need their idea turnkeyed into starting their own business, I help them. So just getting involved. And now my inventors clubs turned into the National Inventor Club. So every month I do monthly meetings virtual where anybody in the world can join. I know it might be a little bit early for some of you, but it's definitely worth it. And if you miss it, it's also archived. So National Inventor Club, it's in the United States, but it's relevant information for anybody in the world.
Wow. Awesome. I think, and your story is so inspiring. It can inspire so many people that, being an IP attorney, I deal with inventors a lot. And I see a few of them are scared in the beginning. Like they have this fear, like we don't know how to do with technology. It is still an idea. Do you need a prototype? Do you need this? Do you need that? So so most of our work is probably counseling them and breaking the process, because the process is also, it's all over the place. It's not one for one country. So most of us is for us also, it's more of counseling, breaking down the process, telling them what to do and things like that. So first of all, congratulations for the book release, and I wish you all the best for that. And now coming back to the question is, what do you think is the most challenging part for the inventors when they come to you, or when they discuss their invention with you or their idea with you?
Yeah, it's with me, but also with you and IP attorneys or agents that are out there. It's really interesting, Priggya, because the first thing, and I'm just going back to when I started, and also the people that I speak to on a daily basis, one of the most important things is who to trust.
Yeah.
And I don't know you. And the first thing that I'm going to is to protect my intellectual property, my idea. But that's the part that's really important. So before I get there, though, I need to know what I'm coming to you with.
Yeah.
So I would say that it's really important to kind of do your due diligence. I know we're excited. Inventors are very excited. And what I count on for IP attorneys or agents, or when they talk to me, is one thing that I do is make sure that the inventor takes away the emotion now from their idea and look at their idea as a business, because they're going to be spending money with you, patent attorneys, right? Or prototypers or manufacturers, whatever, or engineers, product designers, whatever, that they need to look at it from a business perspective and take that emotion away, so you don't make those type of decisions. But now you're putting your time, money, energy, effort into it, and you want to make sure that you're spending it wisely. So I could say that the trust factor is very important, but it's very simple. When you come up with an idea, it's really important to just write it down so you capture it immediately, obviously, no matter what, or leave yourself a voice message or text message or what, capture it, and then spend some time online and put in some descriptive words. Like if you came up with an ingenious name for your idea, most likely you're not going to find it online to exactly what you're looking for, but put in descriptive words and see what comes up in the searches. And then when you're going through the searches, instead of going through website by website and web link by web link, click on images and look to see if your idea is out there or not, just by visually looking at it. If you think it's similar, then jot it down and then be able to go to a patent attorney or patent agent and have them check to see if it's something that already exists or if it's too close to what you have. And is it something that is different enough that you can call your own? And that's the important part that I count on for inventors, to make sure that they do their due diligence and do their research first. So when they give it to you, they have a better conversation with you, instead of just, oh, it's we have to check and we have to do a patent search.
Yeah.
And then what's also important to add to it is a patentability opinion, which is really important, because if you just pull prior art and it doesn't look exactly the same, it doesn't mean that you can call it your own,
Yeah.
right? So we count on the IP attorney or agent to really vet and see what you came up with, the inventor, and what the claims and the patent designs that are out there, the prior art, to compare if it's something that you can call your own. So that's something I'm very, very into, Priggya, is to make sure that the inventor does their due diligence. So when we talk to somebody like yourself, we can really have a better conversation.
Correct. So, Brian, from this conversation, you just mentioned that business size is also important, and sometimes you have to keep our emotions aside and look at it from the business perspective.
Definitely.
But many inventors, I'm sure you deal with them as well. They'll come to you and they're so emotionally attached with the invention that they don't feel like if you tell them that it's not commercializable, not monetizable, they are very attached to their emotions. So how do you handle them? What do you tell them, that should they proceed, not proceed, change, find an inventive step there, or how do you proceed with that?
Well, like I said, step one is to do your own search, right? Go into stores, go online. Step two is to take what you found and give it to a patent attorney or agent to compare and give you a patentability opinion if it's something that's patentable or not. So if you do pull up prior art, is it different enough? Is it something that is already expired, right? So if it's expired, then it's public domain. So I could still make it, but I can't get a patent on it. So maybe I'll come up with a good trademarkable name and continue on my path. But I know that that's something that I'm most likely going to need to manufacture myself or to buy what already exists, and I could sell it. A lot of people do that. If it's something that is potential, then I would continue and work on my prototype and see if it's something that I can get to where I want, so I can protect it with starting off with a provisional patent application, which will give me the right for 1 year to say that I'm patent pending before I file my non-provisional. Or is it a design patent where it's just ornamental, where I'm going to not have to worry about maintenance fees? And I know I lost 5 years off the patent, but I don't have to worry about any maintenance fees. And hopefully I made enough money until then to really brand it with my name.
Yeah.
The other thing is, if it's protected, then realistically, I don't know if you want to continue, because you're going to be infringing on somebody else's intellectual property. So do you want to take that risk? Maybe you want to call up the IP holder. If they haven't done anything with it, maybe you want to work on it with them. Or maybe it's something that they say, you know what, I was happy just getting a patent and putting it on the wall. Or maybe I tried and it didn't have great marketability or commercialization success. So yeah, let's make a deal. And anything is possible, but you know what? You have to be realistic. So when you hit that brick wall, you have to make a decision. Are you going to continue, or should you move on to your next idea? And that's one thing that I put into perspective for people, is to help them to make that decision. If you're going to license it, which I explained earlier, that licensing means that I'm going to a company that already has a product out in the market similar to mine. I'm going to show it to them. I'm going to ask them if they want to add my product to their product line. They'll make it, distribute it, and I'll earn a royalty from it.
Yeah.
So realistically, if you're going to a company like that, which you'll call a licensee and you're the licensor, then most of the time they're going to want to have some intellectual property protection, right? And they want to know that you did your due diligence and you did your patent search and you have some sort of protection on it. Otherwise, what do they need you for? They could just do it themselves, right?
Perfect. Yeah, I love the strategies you just shared. Like we can tell them that if it is an expired patent, you can have a new name for it, and then you can proceed with the technology. Or you can just go and crack a licensing deal. Probably, I think 70% of the patents which are granted are not commercialized. So there could be a possibility that they got a patent just for the purpose of I don't know what.
Well, or they tried. They
Yeah.
tried and it didn't work out, or they ran out of money. Or I mean, when I say they tried, they commercialized it and
Yeah.
it didn't sell well and they stopped. I mean, not every product is a winner.
Yeah.
I could tell you that every product doesn't also have to be a home run. You can
Correct.
have a single, you can have a double. It can bring you in some residual income. It may
Correct.
not be your bread and butter. Look, Priggya, most of the time, somebody doesn't wake up saying, I'm going to be an inventor,
Yes.
right? They have a day job. They're working on somewhere. They have their bread and butter. They have their income coming in. And this is something like, I'm going to give it a try. I want to
Yeah.
change my life. I want to have residual income. I want to be a business owner. Or I just came up with this idea and I want to sell it. What selling necessarily could mean selling what? Selling your intellectual property, right? Maybe it's through licensing, or maybe it's outright selling your patent if you get it issued, or somewhere in between. Anything is possible.
Correct.
Depends on who you're talking to and when. But it's really important to understand that, you have to figure out, is it something that's going to make you money? And is it something that somebody else is going to pay you if you don't have it protected? So that's why the way that I look at things is, if I have a chance to get intellectual property protection, then I do. And if not, I have some choices to make. But, you want to be able to call it your own.
Yes, and I think that decision making is very, very important. Find an appropriate balance, appropriate strategy, appropriate terms. Like, okay, Brian has a patent on this. What can I do? I can just call up Brian and ask, like, what do you have in mind? And probably from that point, I can take it forward.
Definitely.
Yeah. So Brian, now, you have been an inventor, you have been into patenting, you have seen both sides. So what do you think is the right balance? Are there some differences, some gap between the two thought processes, or they are in cohesion with each other?
As far as what, licensing and manufacturing?
No, the patent, like the IP attorneys and the inventors.
I can say that what's interesting is that depending on who an inventor comes to or meets, could be many, many different journeys. So as an inventor, if I just open up we don't have yellow pages or phone books anymore, but if you Google and try to find the latest or the closest patent attorney, which they don't really, like patent agents, they're not sure of, but some patent agents say, we can help you with your patent. So maybe they end up at either a patent attorney or agent. And it's really about, if you don't have a referral, then you're calling up and you're asking them. So what I found, Priggya, is that some patent attorneys or agents end up charging various prices. And that's one thing that a lot of inventors we're kind of like naive to start with, because we just told you our idea, and now we feel like we're hooked onto you, and we have no place else to go because we're going to listen because we just revealed our idea to you and we trust you. So I have some patent attorneys or agents that end up charging for a provisional patent application for a total full patent. So eventually, hopefully, they convert it into the non-provisional and it's already done. But the whole idea of filing a provisional is so you don't have to put all that up front of the full filing fee to be able to get me through just exploring the market. And I feel like there's a lot of variations, like there's also patent attorneys that end up hiring patent agents to do the work. And we're paying patent attorney fees rather than patent agent fees. Look, everybody's entitled to make a living, and you could charge what you choose to charge. Just like anything, you build a home or you have construction in your house, it's up to you to decide who the contractor is that you're going to use, right? You should do your due diligence. You should do your research. You should get your references. So it's important for inventors to really understand who they're going to be working with. And it's good to get references. It's also easy like, here in the US, we use the US Patent and Trademark Office website, uspto.gov.
Yeah.
And when I am introduced to a patent attorney or agent, I can look up on the website to see how many patents were issued in their name.
Yeah.
And that also gives me a good gauge of what kind of business they've done.
Yeah.
And I respect what they do. And it's important. So look, I have different patent attorneys and agents that I've used and that I refer. And I think it's all about making sure that you do what you say that you're going to do, that your pricing is correct, like is fair, and you give the inventor a great experience. We might need a little extra TLC, right? 10 to 11 care. But the
Yes.
thing is that we're not corporations and we don't have, loads of money flying out the window. Although, some people do, because it's important to them to get their idea out there. And a lot of times, excuse me, inventors are coming to a patent attorney or agent, and their expectations are that they're going to get a patent and become a gazillionaire.
Yeah.
And it's tough. So I think it's really important. Expectations, fair pricing, understanding what the process is, that it's not a guarantee just because I pay you that I'm going to get a patent issued.
Yeah.
And one thing, Priggya, that we spoke about last time was that it's really important that patent attorneys or agents, although I respect your opinion on what the marketability of my idea is, I can ask you how many products you've brought to market to give me that kind of answer. So I think it's really important that you focus on protecting me and my intellectual property as an inventor. And if you're getting my hopes up about commercialization to keep me going, that's not fair. I think that's not, unless you have loads of products out in the market and you've commercialized something yourself, then maybe. But I don't know if it's even part of the ethics for somebody to. I don't know. That's your realm. I'm just saying, like,
Correct.
I appreciate your opinion, but you have something else that you're doing for me, which is protecting me. So that's something that I kind of lean on.
So Brian, just to give my opinion on the take you shared. See, for me, what I think is, the people who are coming to us or patent attorneys or any IP lawyer, especially for the purpose of protecting IP, for that, having a science background, having a technological background, having a technological mind is very, very important. They must be from the same technological field. They must understand what technology they're working on, and they should know law as well, because they are good negotiators. If they are lawyers, if they have a good technological mind, they know how to how to lay out the claims, how to lay out the structure, how to lay out the for me, many of my clients would come to me, and then I'll have to guide them that what should go in an independent claim, what should go in a dependent claim, because that analysis is something very, very important, which some people might miss on. So for me, I do not see a patent attorney or an agent should be a person who has invented technology themselves, but they should be people who are able to understand the technology well and put law into it. Like, they have to, especially the claims, because that is the place where we get the legal protection.
Absolutely. They have to understand what you're inventing.
Correct.
To be able to protect it and to communicate it to the patent office.
Correct.
In the way that we want, and protect us from the entire scope of what it is that we came up with.
Correct.
Absolutely.
So that scope is very, very important, and that only a person with technological mindset can do, who knows the technology and who knows the law. So if that clubs together, I think you are in a good hands.
Definitely. One thing that's interesting, Priggya, just being on both sides of the world here, is that a lot of times, let's say if I have a patent, let's say I have a patent search firm from, let's say, India that approaches me and asks if I have patent, inventors to be able to work their patent searches for.
Correct.
I've asked a couple inventors and they were uncomfortable with sending their IP potential across the world to do even a patent search. What's your take on that?
See, for me, I think everything starts with an NDA. Without a non-disclosure agreement, nothing should start an IP. Like for us, we first get an NDA signed and then we proceed with the invention disclosure form. We never get an invention disclosure form in the first place and then get the NDA signed. We always get the NDA signed first and then we get the invention disclosure form filled from the inventor. So I think that in itself builds a kind of trust with the inventors. For the inventors who are more skeptical, like there are inventors who are more skeptical and they believe, okay, even after signing the NDA, I do not want to disclose the technology. So for them, and I don't think it is required, but for them, what they can do is they can just provisionally file an application and then give the patentability search to probably overseas firms. I think that is also a good approach. Whatever they have written, they can file it as it is. And if they find that that was not appropriate, then they can go to next provisional or next a non-provisional directly.
Okay. That's interesting. Usually I tell people to do the patent search first.
Yeah. So
before they file something, because then they might have to file again.
Correct. But I think that is the right approach. Obviously, we should do that first and then file it. But considering the point of view for the inventors who are not open, they can file a provisional application and get the patentability search done before filing the non-provisional. So that at least the scope of the claims is clear. At least they're clear on the novelty and the inventive step, or as you say, non-obviousness in US, and then probably decide whether they want to file a non-provisional or not. Probably at that point, they realize that it is not required. We are not fulfilling the criteria. So they must just do away with the technology and find something new to work on.
Understood. Well, I know that you were interviewing me, but I asked you a question. I'm used to interviewing people. So what's nice, Prig, is, like I love just really my mission. I know something that we were going to speak about. My mission is to really get the word out to inventors on helping them to make a decision. Is it something that they should work on or not? How they should work on it? Is it something that they should license, manufacture to start their own business, license to earn royalties? So that's my mission, is to really get the word out. So between doing the National Inventor Club meetings every single month, and I have the US Patent and Trademark Office as my guest every month. I have the Small Business Administration's Small Business Development Center on the meetings every single month. I also have a whole community of National Inventor Club members, paid and free, which is amazing. Like, I just love what's like, just all the networking and activity going on. But I also have a show. I had a Got Invention radio, which turned into Got Invention show now on videos, that I get to hear inventor stories and their journeys of when they came up with their idea, what they did first, second, third, fourth, fifth, when they came up with it, where they are right now, and what does the future look like for them. And I have those on Got Invention show, which you could just go to Got Invention Tube, which will bring you right to the YouTube channel. But just like getting the right information out to inventors. And that's why I love being here with you also, just to be able to, any inventors out there listening, but also on the other side, IP attorneys or agents and future IP attorneys or agents that are watching this with you and with us, to get the message out, to understand that we're kind of naive to start with. I hate to use that word, but we don't know any better. and we're counting on who it is that we meet. And sometimes we compare and we do our due diligence to know who we're working with, and sometimes we don't. But it's really important that you want to build a great reputation of knowing that you have the patience, that you're fair with your pricing, that you do a super job, that your expectations are giving us what we need to do because we've never done this before and you do it every day for a living, I think is really important for any IP attorney, agent, or future IP specialist that's going to be out there to really help the inventor.
And I think, like you just said, for IP attorneys, it is very, very important to understand the mindset of the inventor. So I think the first calls we do, we just understand that what is the requirement, what is the mindset, where is the technology, in which step they are into, and then take things forward. I think it's not a process like a person will come to you and you will say, okay, you give me information and I'll draft a patent and do every work with you. And unless you understand the thought process and you are into technology with them and helping them do stuff, it's irrelevant. Like
yeah, definitely. And one other thing which is really important is communication.
Yeah.
I know I said expectations, but communication. Don't be shy to pick up the phone and have a chat.
Yes.
Talk, because sometimes you just kind of get in one direction on an email, and there's a lot more that could be spoken about, even to explain what my idea is. I think it's important to write it down and have that intake form, but at the same time, it can help to really understand and maybe open up some other, just more of more that you can put into the application just from a better conversation. So don't be shy, pick up the phone, Skype, WhatsApp, WeChat, whatever it is, have a good conversation with whoever it is that you're working with. And I encourage the inventor to do the same. And if you want to follow it up with an email, that's fine, but have a good conversation. It always works to each other's advantage when people hear each other and have clear expectations.
Clear expectation, and I think along with trust, the trust factors is increased when you do a conversation with an inventor. So they trust you better, you trust them better. So I think it's a win-win situation for both.
Absolutely.
Yeah. So Brian, another question, there must be many inventors who come to you and they must be saying IP is irrelevant. We have heard it through many people that IP is irrelevant. Why should I protect it? So do you face these kind of questions also from the inventor and to guide them to protect IP, or how do you think what is the importance of IP in the field of inventions?
I mentioned earlier, if you have a chance to obtain IP, then you should go for it. But it's you don't have to. I mean, I've licensed products without any intellectual property, and it was kind of based on relationship and trust. But on the other side, if you know that you're going to be manufacturing and starting your own business, as long as you're not infringing on somebody else's intellectual property, then go for it. Come up with a good trademarkable name and keep your idea going through. And you don't need to file a patent. But if you are going to make something or continue, then you don't want to get a cease and desist letter. So it couldn't hurt to do a patent search at least, maybe not file a fully issued patent. I know just because you don't see it in the aisles at Walmart or whatever store is near you, doesn't mean that it's necessarily not somebody else's intellectual property. So keep your eye, there's still, before you're going into your business, this is part of, like with invention, there's research and development with building a company, right? So this is when you're coming up with an idea, you're in business and you want to do your research and development. So what are the options? Well, if I just start making it, am I infringing on somebody else's IP? Am I just making this great? Maybe I'm not. Maybe it's something so unique and interesting. But now, if I make it and I don't have any IP, somebody else can make it too. And I have no protection, and they might be able to make it less cheaper. They might be able to have more money for advertising. And then I wish that I could have filed IP and protected myself, but now I didn't. And my next door neighbor is making it, and 2 doors down is making it. Anybody can make it. So that's what I'm saying. Like, I know that, things aren't perfect, but if you're doing your due diligence and if you can get IP, then whatever you can protect is better than not.
So I'll give you another scenario. Brian will be like,
Okay.
"Oh my God, why is this? She's a patent attorney, and why is she giving me scenarios?" So I'll give you a scenario where a person comes to you and says, "Okay, this is protected in Europe, and I know about it, but I want to commercialize it in US. So it's a
Okay.
European patent. I can definitely commercialize it in US. So should I file IP for that, or what should I do in this scenario?" And people are coming that I want a patent on it.
Well, you tell me. I'm not supposed to be giving any legal advice here.
Not a
But I could
legal
tell you,
advice.
like, from this side,
Generally.
look, I could tell you from this side, and this is only my opinion, no legal advice. But when I come up with an invention here and I protect it, is it possible that somebody can buy it here and then ship it to India and make it? And I don't have any IP rights there, right? I mean, it's public. It turns out to be, or if you make it, then you can't ship it back here into the US because I'm protected.
Correct.
So there's only so much that I can do as an independent inventor to be able to protect myself. So I have a pretty good opportunity here in the United States to sell. I take my chances of selling it somewhere else if I can, and I get distribution and I'm kind of first out in the market with it. But it's tough. I know there's WIPO, World Intellectual Property Protection Organization. Like, there's different ways to protect my idea outside of the US, and that's the same thing with the European side coming into the US. So look, I do the best that I can to make money in my homeland, right?
Yes, absolutely. I think it is very, very important for people to understand. One is like, if an invention is just to point this out to people in general who are our listeners, like if novelty is one of the key point for doing a patent. So if someone has already protection in Europe, you cannot get a protection in US, but you can always commercialize something in US because that technology was not protected there. So I think we have to find a right balance to proceed with.
Yeah, like I have inventions that are sold all over the world. I earn royalties from them. I could sell them and, make them for X and sell them for X, and I'm fine around the world. But if somebody wants to take my IP and do something with it in another country, there's only so much that I can protect. I'm not running to, another country to protect my IP. So, but if they try to bring it into the US, at least I have some protection here.
Yeah. So Brian, now a quick rapid fire round. Answer these questions very quickly.
Okay.
3 things you are grateful for.
I'm grateful for what I've earned and what I've built. Well, I should start off with, I'm grateful for my family. I'm grateful for having an inventive mind and being intuitive and loving doing this and being able to share this with everybody else. I mean, I feel like this is my mission to get the word out and help as many people as I can.
Wow, awesome. Now, 2 traits you think are useful for someone in your field.
Well, I think that being intuitive, I know I've used this word a couple of times, but I think it's important. Like, you can come up with something, but how is it going to be used? Who is going to use it? Are enough people going to be able, going to want to use it that it's going to make me money? Right? So I think that's pretty important. What was the question again? Because I only answered one, right? 2
traits or habits that you think are useful for someone in your field.
Okay, so I said 1, maybe it was 2 already. But another one is just following through and keeping your word and being straight up with what you're coming up with or what you say, and make sure that you do what you say.
Wow. Do what you say and be intuitive. Absolutely amazing. And now, one aspiration you have for the future.
My aspiration? keep on inventing more items and products and just getting it out there and helping other people with their inventions. I mean, I look at my ideas as, yes, I've hit singles and doubles and maybe a triple here and there, but I'm looking for the home run. And I don't know if I'm ever going to be satisfied, but maybe I'll always have the home run open for hitting a home run. But, one thing, Priggya, like that is really special to me is that I love when somebody's using my invention for the same reason I came up with it.
Wow.
Like I can go to the store and I see my product on the shelf and I see somebody grabbing it and looking at it. I'm like, oh, that's awesome. I have one of my latest products that I invented was a year and a half, 2 years ago when we were all stuck in COVID, and people were like cherishing and like their paper towels was so like, it was hard to get paper towels. And I started to use them. And I was very like, you have to be careful with these paper towels. It's so valuable these days. So I started to use the paper towels, and I noticed that when I use it, I put my hand on top and I rip it off, right? So when I'm doing that, my hands are usually wet or dirty. That's the reason why I need a paper towel sheet.
Yeah.
So what I did was I asked people, let me see the top of your paper towel roll. And it was disgusting. Tomato sauce, dirt. It was wet, then dried up, and it was shriveled up. So I started to ask people, and I saw that all of them had this same thing going on. So what I did was I came up with this top that goes on top of a paper towel roll. So if you have a stand and you put I should have brought it down, but you have a paper towel stand and you have the paper towel roll on it, and I put a cap on top. So now whenever your hands are wet or dirty, you put it on top to pull it off. So it keeps it clean and dry. It's simple, papertoweltopper.com. So I was saying, Priggya, that to me is simple. I have it on Amazon. It sells. I'm very excited how it sells. And I love the reviews that are on there. Like that is like, I don't care about how much the, margin is and all that. I do because I want to make money with it, and I do. But just to know that people are using it going, I love this. It's a great product. I don't, everything's clean and dry. It does exactly what it says that it was supposed to do. Like, I love that. So that's what keeps me going.
Awesome. So. And I think with your story, it's very important to understand that technology should not be this big to be commercializable. It can be a simple invention which you're just solving a problem around you. It was your problem, you solved it, and that's how people got a new invention.
Yep. And you know what? I've worked with people in practically every category. I work with doctors and construction people and novelty items and hardware. It doesn't, people are looking to build apps and platforms. It doesn't matter. And it doesn't matter who you are. You could be a doctor, lawyer, senior citizen, student, unemployed. Everybody's an inventor at some point in their life. Yes. They just might not call themselves an inventor, but they are. They're coming up with something that's unique and new. And there's certain people that capture that idea and keep going, and others go, I'll wait for the next person to come up with it. Maybe I'll see it out there one day, and I'll be the one that says, I woulda, coulda, shoulda. It wasn't me though, but that guy did it, or that girl did it. But you got to capture it and give it a try. And as long as you have these type of opportunities to hear good information to keep you going through the steps and making good decisions, you could have the next gazillion-dollar invention. It doesn't matter if it's an app or some technology or just some kitchen gadget like I came up with.
Yeah, absolutely. So Brian, now coming towards the end of the podcast, so can you share some key takeaways for young lawyers and entrepreneurs, people who are young in minds?
Sure. Well, you're talking about ones that are going to become IP attorneys or agents. Well, yes. We mentioned it earlier. Listen, we are counting on you to protect us, to give us good information and be fair and focus on the intellectual property side of it. Don't paint big pictures for me that this is going to be all this money that I'm going to make, and it's not fair to do because it's supposedly not out there. And if it is something that realistically I'm going to hit a brick wall with, it wouldn't be such a terrible idea. Like, give me some of my options to know, instead of, hey, I'm sorry, it's not patentable, come up with the next idea. Like, if you wanted to continue, then maybe you should think about a trademark. Maybe you should just sell it because it's in the public domain already and start your own business with it. And maybe if you sell enough of them, then maybe you can modify it enough so you could call your own. But you could start off right now with selling it just the way it is, as long as you're not infringing on somebody else's IP. So give me some options. Be fair, keep communication open, do what you say you're going to do, get back to me, and know that I'm vulnerable and I'm looking to trust you. So make sure you build that trust with me.
I hope every IP attorney listens to this. This is so interesting to, you have shared heart of an inventor with an IP attorney.
Good. Well, that's up to you. I hope everybody has a chance to listen to this. I enjoyed this. Thank you, Priggya.
Thank you so much, Brian, for your time. And thank you so much for being here.
Thank you. Thank you very much.
Hey there. Thank you for attending today's session. If you enjoyed today's session, do follow our channel and consider sharing it with a friend. My name is Priggya Arora, daughter of inspiring parents, alumna of IIT Kharagpur, engineer turned lawyer and entrepreneur, and now founder of PA Legal, where we help creators and innovators protect their intellectual property. Thank you.